Hi, I'm Chris Chimicles, president of Angeion Group, and welcome to our Leading Litigator series. Our series brings together some of the best and brightest class action practitioners from both the plaintiffs and defense bars, and most importantly, the attorneys that made case law. Enjoy our series.
Hello and welcome to another episode of Angeion's Leading Litigators video series. Today it is our distinct pleasure to have Tim Blood, the managing partner of Blood Hurst O'Reardon, joining us. Tim, thank you for being here.
Steve, thanks for having me.
It's our pleasure. So, Tim, recently you had a pretty sizable settlement, and I'm sure our viewers would love to hear sort of the history of the settlement, the case, how it came to be, etc. Can we talk about that?
Absolutely. So this was a great example of lawyers working together. We actually didn't use a mediator with it. We had, I don't know, more than a dozen face-to-face meetings. There was a lot of things to work out, a lot of things to negotiate, but it was just done lawyer to lawyer, sort of the old-fashioned way. Mediators can be great, but with a complex settlement like this, it really worked best just to work lawyer to lawyer, working through the issues, and everyone was really trying to reach the right result.
Tell us a little bit about the case and maybe a little bit about the negotiation process, because that is, as you identify, not in today's world the normal course of events.
So the case is pretty straightforward. It's frames of certain Toyota vehicles rust out prematurely. There was a problem in the manufacturing process. And so people would have their vehicles and the frames would rust out to the point where they were unsafe. So under the settlement, everybody gets to bring their frames in. They get to bring their frames in as often as they want for a period of time that runs from 12 years from when the vehicle's first purchased. And then if rust is found on the frames, then the frames get replaced. It's pretty much that simple, but the details that go into it are pretty complicated.
So Tim, can you just kind of take us through how it all worked without the benefit of a mediator, how many sessions you went through, because it's obviously an immense settlement and it's not the normal course of events, and I think that our viewers would really like to understand sort of the back and forth and how it all went down.
So it took place over the course of many months. We had well over a dozen face-to-face meetings, lots and lots of phone calls, and it was just really a matter of working through issues and actually discussing what the issues were, what each side's issues were, and trying to find common ground with every issue that arose. From the defendant's standpoint, the job of getting frames for inspections and then frames for that many vehicles, there's about 1.5 million vehicles in the class, is an enormous undertaking. And so there were some timing things that we wanted to do very quickly, other things we simply couldn't do very quickly given the magnitude of the settlement. And the defendant was motivated, obviously, in making sure that people who had unsafe cars got taken care of first. And so we just worked through the issues, and it helps to have a good working relationship with the other side. And so often we're fighting with each other in litigation, but at some point you need to put down the guns and work together. And I think the best lawyers are the lawyers that can do that.
Certainly, I agree with you. On the flip side, you're one of those lawyers, though, that also, forgetting knowing when to put down the guns, you know when to re-up and come in with the bazookas, because you're one of the few people I know who has actually tried multiple class cases, correct?
Yes, yes.
How much do you think that your reputation as someone who will take a case to trial, who has taken a case to trial, helps you in your settlement negotiations?
I hope it helps a lot. And I'm not afraid to take a case to trial. I think it's important that plaintiffs' lawyers take cases to trial. I think the class action bar should probably be taking more cases to trial. Too often the ones that get pushed into trial are the weaker cases. It's sort of the nature of how trial works from a plaintiff's perspective. But there's also plenty of cases that should be pushed harder and brought to trial because cases are settling for too little money sometimes.
So the cases that you have tried, where on that kind of continuum did those particular cases fall? Were they weaker cases, or were they cases that you said, you know what, that's just not the right offer, and I'm going to get the right amount for this class? It's
sort of a combination of both. It depends on what stage of the litigation you're at, whether defendants really think that the case is going to go to trial or not. So it falls along the spectrum.
Sure.
And so often what you find is if you're willing to take a case to trial, then the defendants end up coming up to that number that you think the case should settle for anyway, so it obviates the need for a trial.
Sure, makes sense.
But it's important to keep that threat alive and to prepare the case properly.
Yeah, of course, of course. So as we sit here today, we are very close to the end of the comment period for the new proposed rules to Rule 20, the proposed amendments, I should say, to Rule 23. Two of the most interesting and most present, I think, in terms of your practice and my business are the objectors provision and the notice provision. And I was hoping I'd get your thoughts on each of those proposed amendments.
Well, the objectors have been a problem for years and years and years. So anything that can happen, any changes that occur to improve that process is a change in the right direction. Objectors have just been a tax on the system and inefficiency. So I think that the proposals are good. They're a step in the right direction. We'll see how they play out going forward. But I think everybody in the bar should applaud those rules because they really are an improvement.
Let me ask you a harder question, though. I mean, I think that everyone on both sides of the V are going to agree that professional objectors are something that no one likes, right? Is there a place for valid objections, non-professional objections within the rubric of Rule 23?
Oh, absolutely. I mean, the objector process itself, I mean, it's critically important to how Rule 23 works from a due process standpoint. But if people were honest, they would realize that objectors do play an important role. I think if a case is closely looked at, settlements are closely examined, there usually is not any room for real objections. However, every once in a while you realize that there is a group of people out there that maybe everyone overlooked.
So the second proposed amendment that I want to talk about is the amendment to the notice provisions. Obviously a subject of great interest to me. And the key language that I want to focus on is electronic or other means. And from your own personal perspective, and then I'm going to ask you to speak as sort of the figurehead of the plaintiff's bar that you are, how you feel the plaintiff's attorneys feel about it, and even if you think there's a difference between plaintiffs and defense perspectives, just overall what the proposed amendment means and its implications.
Well, I think notice is the one area where class actions are decades behind the rest of the world. The law tends to move slowly. It tends to move slowly for good reasons. There is no good reason for how slow the notice provisions have moved, and we still need to go a long way to updating notice provisions. Coming from California, California has a completely different rule with regard to notice. There is cost shifting, there is tremendous flexibility to allow the parties and courts to formulate notice programs that make sense for the particular case. It results in much better notice programs. The problem, of course, is that most significant class actions end up in federal court. So those rules are not available. But we know from experience, and the California rules have been in place for quite a number of years, that those rules work much better than the federal rules. So we need to go a long way towards improving notice programs. The defendants, in many, many cases, have a different incentive than plaintiffs do when it comes to notice. Depending on the type of settlement, how it's structured, defendants often have an interest in making sure that notice is not sent out to result in lower payments that the defendants have to make. And oftentimes you'll have a defendant who simply doesn't want the world to know about their alleged wrongdoing. And so they feel that less notice is more. That's always going to create a conflict. And what we've seen getting worse and worse in recent years in the federal system is that the plaintiff's hands are tied when it comes to negotiating notice programs. The outdated rules that exist in federal court today help defendants tremendously, even if they don't want that help, and even if they want to do a different type of notice program. What it ends up happening is the current notice rules are terribly inefficient, they're incredibly expensive, and they just don't work very well. There are such better ways of reaching people and paying out money, much more efficient ways that will lower the transaction costs, and we really need to bring up those rules into the 21st century.
So Tim, I obviously agree with you, but my question, I suppose, more specifically is, does the new language in the proposed amendment of using electronic or other means get us to where we need to be?
I think we're going to have to wait and see how it's interpreted. I hope it does, it should. And if you combine the new language with actually the old cases, the cases from the 1950s, 60s, 70s, starting with Mullane versus Hanover Bank, those cases actually talk in terms of making sure that an intelligent, flexible approach is used to reach people. Back in the 1950s, the best way to reach people was by mail. People would get mail. There was a lot less junk mail. They would open their mail. They would take their mail seriously. And you could imagine back in the 1950s having a very good response rate. Fast forward to today, and you have a very, very different experience. People get lots and lots of junk mail. People don't look at their mail as carefully. And so there are far better ways of reaching people than simply sticking something in the mail, depending on the case. Some cases, direct mail is still the best way to go, but it all depends on what approach is needed for the particular case. So I think the hallmark is flexibility. When you look at the new rules, they suggest flexibility. When you look at cases like Mullane, they really order flexibility, and it's that flexibility that's been completely lost.
It's funny you say that. I mean, I reread Mullane fairly recently, and there's a line in there, and I'm going to butcher it, but they're discussing the mails, and they say something about the mail being now considered an inexpensive and common form of communication. And when I read it, I mean, Mullane, I think, was written in 1950. What's the most inexpensive and common form of communication today? I would argue it's email. So I think that some of the language and the reasoning behind Mullane that they used to justify direct mail in that case would be equally, if not more, applicable to email in today's day and age.
Yeah, absolutely. Email is critically important. The internet is critically important. Anything that allows somebody to act very quickly in submitting a claim is going to be very good. And I think what practitioners and courts have forgotten is the notion that the way people behave today is different. Things happen much faster now than they used to. So back in the 1950s or 60s or 70s, someone would receive a letter, they would put it down, they would pick it up again, and they would take action on that letter. Think about paying bills. People would get a bill in the mail, they'd sit down, they'd write checks. They would take the time to take the action necessary to participate. Today, if you get something in the mail about a class action, you may or may not actually follow up on that and submit a claim. So people's perceptions, the psychology behind action has shown that people change based on technology, their habits change. So we have new habits and a new technology that's driving those new habits, and we need to make sure class notice keeps up with those. So things like internet access is fantastic. People can click on a claim immediately, right when they get it. It's going to affect take rates. It's going to make the system much healthier because people will actually be able to participate in settlements.
No, I think that's absolutely correct. Just as sort of a side note, we had a case where there was, virtually equal amount of email and mail. It was a low recovery, under $15, and the claims rate amongst the people who received the email was significantly higher than the people who received the mail. I think it goes back to your point about flexibility. If this had been a securities case where you had hundreds of thousands of dollars potentially on the line, people want first-class mail, they want the ability to respond, but if it's just clicking a few buttons attesting to a product purchase to receive a sub $15 settlement, I think it's logical and intuitive that more people are just going to click on the email and move through the system that way.
Flexibility is the hallmark. I had a case, it was a while ago, but the principles still stand. We had a multi-pronged notice plan, and at the time it was absolutely the state of the art. The population the class population was a group of people who didn't really consume media. And so what we ended up doing is we put notices in community centers and churches in the South where class members were likely to go. We then had two 800 numbers, one for the publication, and to the extent we had mail process was one 800 number, and then the community centers, the posters that we put up had a different 800 number, and the rates of response were much higher on the community center postings than on the periodical postings. And that's because we developed a notice program that actually fit the class audience. And it worked well, and I think those lessons apply even more so today. So sometimes sort of the town crier posting notice may still be the best way to go, and it requires thought and a good notice administrator.
Tim, I couldn't agree more. This has been great, and I think that our viewers are absolutely love hearing your perspective on all these issues. So thank you again for joining us.
Thanks again for having me, Steve.